You're back.
Very good. I'll just sit in and wait then. Very good.
Okay, so Kent, you're going to go first.
I'll go
right?
first, and I'll turn it over. Yeah, I'll turn it over to Tony, and then when Tony's through, I think then the transition goes from there to Jeff. However that'll work. But Tony will be working off my same screen,
Okay.
and I'll put up her last slide. So Tony, you'll be good for all of our screen purposes.
Correct.
All right, well, I have started the recording, so we should be all good to go. It's 2 o'clock. Shelly, you ready?
Mm-hmm.
Beautiful. All right, I'm gonna let everybody in. Let's do this.
Well, good afternoon, everyone. Welcome to ACEC Georgia's first of what I'm afraid there will be several of virtual meetings, virtual programs, virtual professional development opportunities. This one in particular, as you know, is focused on managing the risks around the provision of private plan review and inspection services. Just to give a little background of kind of where we are or how we got to where we are now. In 2018, ACEC Georgia, working in concert with the Associated General Contractors of Georgia, revised Georgia Code to provide for the ability of owners to immediately go to the private sector for plan review and inspection services. That code section was signed into law by the governor in May of 2018. And it's a good thing for all of us that it was, because when the governor's state of emergency was declared, and prior to the governor's shelter-in-place order, a lot of local governments were shutting down. They were not providing inspection services or plan review services. And so we immediately began working with the governor's office on the issuance of an executive order that would require that to occur, allow private developers and owners to avail themselves of licensed professional architects and licensed professional engineers to provide those services pursuant to the existing law that was already in Georgia Code. That order was expanded a couple weeks later, or about a week later actually. The current Georgia Code as it stands does not allow for private plan review or inspection in instances where you have certain critical structures like hospitals and high-rise buildings. The governor issued an executive order to include those structures so that now all types of structures, all types of plan review and inspections can be performed by private sector engineers and architects. So that's kind of how we got to where we are. Obviously, there are a tremendous number of questions and issues around those the provision of those services, and particularly what the risks are to you and your firms in providing those services. And so that's why this program was put together. We have a great lineup of speakers in alphabetical order. We have Tony Mack, who's a partner at Copeland, Stayer, Kingma, and Level. She's an experienced litigator in the firm's construction practice. Lots and lots of experience in representing architects and engineers in a variety of design and construction phase litigation and disputes. She is also a cum laude graduate of the University of Georgia School of Law, go Dogs, where she was a member of the mock trial team. I was also on the mock trial team at University of Georgia School of Law, so I guess we got 2 alumni on there of that. And she has practiced with a firm in Savannah prior to joining Copeland Stayer. We also have Jeff Mitchell, who is Vice President of the Insurance Offices of America. I'm sure everybody knows Jeff. His practice, he leads the Architects and Engineering Professional Liability practice at IOA, and is no stranger to our industry. He is a very experienced insurance professional with more than 20 years of experience in the A&E insurance industry, and working with over 250 firms in the AE space, helping them with their risk management issues. He also sponsors yearly professional practice seminars for all of his clients, and brings industry experts such as the ones that we have with us this morning or this afternoon. And last but not least, because he's actually going to go first in order of speaking, is Kent Stayer, who's also a partner at Copeland, Stayer, Kingma, and Little. with over 30 years of experience in representation of design professionals in the drafting and negotiation of their contracts, litigation, arbitration, mediation, any types of disputes in that area in the AE space. So we have a top-notch, world-class panel of experts who will answer every question you could possibly have, and I'm sure at the conclusion of this, you won't have any more questions left. With that heavy burden, I will turn it over to Kent.
Very good, very good. Good afternoon, everyone. In 2 years, I'll be able to say I've been representing design professionals for 40 years rather than over 30, and it has been a pleasure that I've had. I will tell you, I've gotten to know a lot of you, but no one of you has ever called me to tell me that a project went well. Literally in 38 years, the only thing I know is that every project goes poorly because those are the only ones I see. And over that period of time, I guess I have developed something of a jaundiced view on your behalf. And I have become concerned about all the things that may go wrong. And what I want to talk to you about today are the risks that are involved. I mean, that's what I do. I defend folks when risks were taken and someone makes a claim against them. And so I'm going to view the statute from a risk standpoint. And if I were looking at it as your lawyer, what kind of things, concerns would I have? Over the years, I've done a number of risk management seminars, and one of my favorites is entitled "Gravity is the Only Law That Can Be Certified." And I came about because of a case that came out of Savannah, Georgia, which is one of the most interesting legal cases I think I've ever seen. There was a shower door that did not have tempered glass, and some tenant of the apartment's arm went through it. Lawsuit ensued. The code, the designer was not involved. Frankly, there probably really wasn't one. There was remodeling of an old apartment in Savannah, and so the question became, did the landlord provide a shower glass door that did not comply with the code? Well, you would think that would be a relatively simple issue to trace down. It went through years of litigation and in the end wound up with a 4-3 disagreement at the Supreme Court as to whether the shower glass door complied or did not with the building code. And the discussion that they give is absolutely classic about there probably 10 or 15, 20 overlapping codes and ordinances and conflicting this and interpretations of that went into this tremendously complex legal analysis, and ultimately it was decided it did comply. Interestingly, the code official came as an expert witness on behalf of the plaintiff and gave the opinion it did not comply, and yet the Supreme Court said, well, code official, you're wrong, it did comply. And so the case really stood out in my mind when I see all these people being asked to sign certifications of code compliance and so forth. I say, folks, you just can't do it because every code is like a law. It's subject to interpretation. And so there's just very little black and white of what you do. And, you know, as I thought about it, if that's a shower glass door, when you look at the complexity of buildings and every other code that has far more difficulty to understand, I would think, being subject to the same questions, it sort of tees up this idea that, okay, now you're going to be the code official and you're going to have the responsibility for interpreting the code as the final authority of the jurisdiction, if you will. What does that do and what does it not do, and what exposure, if any, does it give you? And I will kind of give you the punchline in the beginning so you can kind of keep an eye on it in the end. The biggest concern that I would have of the whole thing, and it's a concern that you need to come to grips with and deal with, is that code officials are all immune from everything they do in the interpretations of code and in the inspections that they make. And so they can go out there and they can interpret something one way and in the end be found to be totally wrong. And they say, well, gosh, that was just a bad day at the office, or maybe I'm sorry those people disagree with me. But the point is that no civil liability can by law come from that. And that's a comfortable place to be. Unfortunately, when you become a private provider, this law does not provide you with that. And so you're going to have essentially the same kind of civil liability exposure as the plan reviewer and the code inspector that you would have if you were in private industry. And so you say, well, I guess I've always had that all along. What's different? I guess what's different is that you're going to be exposed to a wide range of differing things that were not your original design work, and you're going to be called upon to give interpretations. And if there are erroneous interpretations that will have some catches in them that we'll talk about, then that can be a delay issue on your part. It can be a lot of issues on your part. And so I do not want to be a cold shower thrown on what's an opportunity that is really extraordinary. And I say, like Michael did, it is really, really helpful that the legislature, and I think the ACEC had a lot to do with this in its establishment, that this law was in place because there is now, as you all know, a very urgent need for building officials, and for whatever reasons with government layoffs and slowdowns and things like that, they may not be available, but the projects need to continue going. And so it's really, really, really good that this opportunity is here. It can provide those of you out there who are interested in taking advantage of it a new source of revenue, if you will, and professional activity. I just ask that you take the reward that you can is rather obvious and understand the risks, and that will be the purpose of our discussion here today. And so now I'm going to try to go through my slides, which I think I'm in control of. Let me see how this is working. Okay, aha. Okay, so Michael has introduced to you the executive order. Most of you already know about it, and so I'm not going to say too much about it. The language, though, that he starts with in the order is something I do think is important. And he says he's determined that the counties and municipalities who regulate inspections, and you'll see the language in there, to ensure compliance with the minimum standards. Well, I'm the lawyer who will tell you in a contract never sign up for anything that insures. And yet the whole premise of the starting point here is that there's a group of people put in place by the counties and the states to ensure compliance. Now that doesn't mean, because he uses that word in that context, that you are going to be found legally liable for insuring. That's not the case. You'll see that it's a standard of care issue and it's not an insurance issue. But the point is that it starts with the premise and it uses the ENSURE word, and I would not urge you to do that. So, and then he goes on and says, and because of the absence of timely people or people that are able to provide that service, we're going to let these private folks do this kind of thing. And so now we're off and running. And that was simply just the suggestion that the premise starts off with a word that, as your lawyer, I take out is a matter of concern. All right, and then he says, I'm just going to go through the executive order, and it should not be hard to follow as we go. It says the provisions will expire at the conclusion of the state of emergency. Well, so in other words, when all this comes to an end, and we certainly all hope that in the foreseeable future it comes to an end, what happens to people who are already then in play? And frankly, the code doesn't address it. I suppose and hope and expect that you'd be able to continue with the task that you were assigned when the order was in play, but that's really an unanswered question. But for the purposes here, it's not particularly important. It's something to keep on your radar screen. The important thing is what is the code that you are then called upon to act upon? So the executive order says, folks, you're now entitled to do what it is in the code. So let's go to the code and see what it says. And I just note here that, it's a 6-8 page thing. And it generally speaks in English that folks can understand, but you need to read it all carefully. I'm not going to read every part of it here. You need to read it. And I would urge you to look particularly at the timing requirements that are involved in this, because, it's important that you all do things timely, whether you're the code official or whether you're the architect or the engineer. You got to act timely because delays is what costs everybody money. And I've told everybody on all my seminars that I buy books and pencils for my kids, or I did when they were kids, with errors and omissions, but I paid their tuitions with delays. And my son went to Wake Forest, and that's no small tuition to pay, but it all pretty much came from delays, because that's really where the big money in claims, the big money in litigation, it's the big money you want to stay away from. So whatever you do, understand my focus on timing and scheduling, because that's so critical to the projects. To be a private professional provider, which I'll just call private provider for the purposes, if you have to be, of course, a registered architect and engineer in the state of Georgia. And it's critical, the language says you cannot be an employee of or otherwise affiliated with or financially interested in the person, firm, or corporation engaged in the construction project to be reviewed or inspected. And so what they're really looking for is, like the state official, the local official, it's somebody who does not have a dog in the fight and is not financially associated with them. And what that really in the end is going to mean, I don't know, but I urge you, do not get into a situation as a private provider in anything that has a bad odor as to whether you're too close financially to the owner of the project. The worst thing that can happen is, unlike a code official who may not be subject to the same influence or attempt to have influence exercised over them that owners might do with someone they know, if they know you on a private basis, and particularly if they've hired you in their minds to be your code official or the inspector, they might expect they have some ability to influence you more than they would have to influence the code official employed by the state. You cannot let that happen. You have to keep an arm's length transaction. It can't be a wink and a grin. It has to be real. And so make sure that you are truly an objective observer of the activities and a provider of things. Because if there is one of these misinterpretations, or excuse me, it's not really a misinterpretation, it's a differing interpretation. If there's a differing interpretation and somebody has the ability to say you shaded it toward the owner and against health, safety, and welfare and stuff, that's going to be a bad day. And so don't allow anyone to start the discussion with that suggestion. Keep a good distance. All right, now it says next, of course, you do it in accordance with the provisions of the code. Well, that's something of a duh. They want you to do what the code official will do. And they say specifically in here, and up at the top, you'll see the sections specifically. If you go to 8226G, this example, for example, is paragraph 8. And as I go through these, the 8, 9, 10 will be literally the provisions. So if you want to go read them more closely. And it says basically that the code review or the inspection will be no less extensive than what would have been done by the government official. It doesn't have to be more extensive, but it can be no less extensive. And so that's the bar you have to clear. Subsection 10 outlines the core requirements and expectations, and you need to read it and understand it. The selected key provisions, as I say, that it says that upon determining that the plans comply with the applicable regulatory requirements, the provider shall prepare an affidavit on a form adopted by the Department of Human Affairs. So in other words, once you have completed your review, and once you're satisfied that in your opinion and interpretation and review of things, it complies, your task then as the final exam is to sign an affidavit that says some things. And the affidavit can be found at that website. They've already prepared it for you, and so you can see it. I have looked at it and, of course, have a copy of it. And I will tell you the most critical statements, I think, in the affidavit, and this is redaction, but these are all quotes, but it's just a part of it. But this is what, to me, is at the heart of my concerns with it. Is that it says that I'm who I am and I'm certified, qualified to be who I'm supposed to be and doing what I'm doing. I certify under oath that the following is true and correct to the best of my knowledge and belief and in accordance with the applicable standard of care. So you're not insuring either with an E or an I or ASS, however you want to spell assure, insure. You're just saying that to the best of my knowledge and belief and in accordance with the standard of care, still though you're certifying something under oath, don't take that one lightly. That means something. But the critical statement that you do, that's the heart of it, it says that B, the plans comply with the Georgia State Minimum Standard Codes for Construction, most recently adopted by the Department of Community Affairs, with Georgia State amendments and any locally adopted or ordinances and amendments to such codes. So you got to really keep up with a lot of bouncing balls. You got to have the code down, which everybody says, well, of course I know the code is the code. And then you've got to know whatever amendments there are. And then more importantly, you have to know any locally adopted ordinances, and you have to know of the amendments to those locally adopted ordinances. And I say that because a local code official is going to know their locally adopted ordinances and amendments like the back of their hand. The odds are they probably wrote most, if not all of them. But if you're in Atlanta and you're looking something in North Georgia or South Georgia, or if you're in Rome and you're looking something in Savannah, or if you're anywhere else in different places across the state, and you're in a locality that's not one with which you're familiar, just understand that when you interpret the code and you say they comply, it's more than the book that you've got there on your desk, which is the state minimum code. So it's a body of work that you have to be responsible for, where you're going to certify under oath that they comply. So keep in understanding the magnitude of the responsibility. All right, now the code section 11, it does require you to have E&O insurance. So again, code officials don't have errors and omissions insurance. They don't need them, because if they were to get sued, somebody's going to go to the Constitution of Georgia and the laws that back it up and say the guy can't be liable, go away. You're not going to have that liberty. And instead, to the contrary, they say we want to make sure you are a financially viable entity. And so you need to check with Jeff or your broker, whoever it might be, to make sure that the requirements in the code, and I'm not going to lay them out here, make sure you've got them applicable to the project, because that's going to be one of the requirements. And also it's going to be something with prudence you're going to want to make sure you do. Code section 12 says this is what you can review. And Michael said that the governor expanded it by a subsequent executive order. I'm going to talk about that in a moment. But this was the one that when the law came out a year ago, he said this is what you can do, and it's a pretty broad scope of stuff. I mean, it's about every element of a building, and it says so you can do all that thing, and then it says provided that the plan review or inspection is within the scope of such private professional provider's area of competency. Okay, now the lawyer in me radar goes up. And I can see where the next piece of litigation is going to be. The first piece is that, well, you know, that plan reviewer, that inspector reviewed something that they just weren't qualified to do. You know, there's a mechanical engineer and he was reviewing structural stuff. He's an architect and he was reviewing electrical engineering stuff. You know, it's just not in his area of expertise. And so what I urge you to do is don't do anything as the inspector that you would not as a professional take your seal and accept professional responsibility for. And if that means you have to have a team of people working with you to provide a level of expertise and interpretation that you need to, then that may be just what has to be part of the requirement. So, you know, if you are a structural engineer, and you just don't really understand electrical engineering, I can tell you join a lawyer who has represented a lot of structural engineers who still don't understand electrical engineering. You know, you don't want to really be saying that complex situation there complies with the electrical code and all the amendments and the like. You really need to get somebody who can say that. And so if you bring this body of team of people together, you'll do well. If you don't, you won't. Now, you're going to say, well, every code official is not licensed and registered and qualified in every area of practice. They're not. They, though, have spent more time looking at the breadth of issues that they've got to deal with in the code. They can ask questions. They can do whatever they want to do. And again, I don't want to lighten their load, but it is a much lighter load, because if they get into an area that's not really one of the things of great expertise they've got, and if it is, you know, it is some differing interpretation, I'll be polite and call it that, you know, they're not liable for it in a civil sense. You will be. So make sure you don't stick your nose in the business of the plans and sections of plans and parts of buildings that really you're just not competent to do, because this language will come back to be something you'll see in the future if you don't. All right, now, the local authorities are required to accept so in other words, you've gone out there, this deals with inspection. So by the way, I must say that what you cannot do as a private person is you cannot issue a certificate of occupancy. So down the road, ultimately, the code official of the county is going to have to issue a certificate of occupancy. You can't do that. But let's assume now you've reviewed the plans. There's been a permit issued. Life is good. Construction's underway. And then you're out there inspecting it, again, as a code official would do. And what this says is that when you issue an inspection report, then the local code official has basically 2 days to raise a question over it if they choose to. And if they don't, within 2 business days, give you a written indication or indication that your report is either incomplete or the inspection was inadequate, then it's accepted as adequate. And then when they give you a deviation report, if they will, or whatever you might want to call it, they also have to provide you the description of the deficiencies and the specific regulatory requirements that they don't feel to be adequately addressed. Well, the problem here is that you've got sort of someone who has the right to look over your shoulder, but they don't have the obligation to look over the shoulder, and they don't have to do it, and they may not do it all the time. They may do it sporadically. You never know when they're going to do it, when they're not going to do it. But basically, you can be second guessed on any given inspection, and then if they want to harp in and say, well, I'm sorry, I don't think this is right, then your work comes under scrutiny, and if that causes a delay, again, delays are the thing that caused me to go and suggest you go buy a big bottle of Tums, because that can be a problem for you. So just understand that your work is not the final word. There are people who will be watching after. We'll talk about that a little bit more as we go. There's a pre-qualification process that the authorities might have if they choose to. I don't know, but obviously, if you're going to get into this line of work, you need to check and make sure if there is a pre-qualification that you need to follow, that you do so you'll be in place and ready to go if you get the assignment. The liability issue of it here is sort of centered, not centered, but it's reflected in this language. This is section 16. It says nothing in this section, this code, this executive order, will be construed to limit any public or private right of action designed to provide protection, rights, or remedies for consumers. Well, I tell you, when you say lawyer right of action, they'll tell you, oh, you want a synonym for that, that's a lawsuit. So nothing limits lawsuits by anyone in the public or private sector that's designed to protect the rights, remedies, or protection for consumers, which is pretty much, I think, a broad base of people out there who might get hurt by whatever happens. And so there's a world of people out there who, in the end, get to seek redress from you if they're dissatisfied with what you did and want to suggest that it had some role in a problem they've incurred. Michael said originally, and I mentioned also, that the original act as written said these are the kinds of facilities you can look at. Section 17 said, well, these are the kinds of facilities that are not covered by that law, and that you cannot inspect or review. And they're listed in a little bit more detail, but generally speaking, they can be grouped as various medically related facilities, jails, airports, facilities for national security, high-rise buildings. These were ones that they said, you just can't do that. But as Michael mentioned, and as we'll discuss here, that was amended by this executive order of March 30 that came out, signed March 30, of course. And it says that this order does allow for the law to apply to plan reviews and inspections for those projects that are in Section 17. So in other words, you can get in and do hospitals, and you can do other things if you choose to. I will tell you, I would urge you to not, again, get outside the scope of your skills. This morning, I spent an entire morning dealing with somebody who's doing something with a hospital, and basically they're rushing under the emergency need for additional isolation beds and taking space and creating space that the COVID-19 people need for whatever reason. And they're not able to do it if you were to take every interpretation of law to its literal sense. The time it would take and the expense it would take to convert some things to what is urgently needed simply couldn't happen. And so some of the code officials in hospitals, for example, CDC says 6 air exchanges an hour are good, even though ASHRAE says we need 12 in a given situation. And so the code officials in charge of those, I think, are allowing the 6. And so the question is, well, how do you do that? My suggestion is you do that very prudently as an engineer. When the code says one thing, the circumstances and the code authority say another thing. But that really, the point is that there's a lot of complexity in that. But now, if you were the authority jurisdiction at that particular situation, I will tell you, don't start taking a loose interpretation of the code because somebody from the CDC tells you, well, it's okay, this is all we need. And again, so it kind of adds to the complexity of what your role will be. So again, stay within your lane as it relates to the kinds of projects that you become responsible for as the private provider. Now, here's the thing that is, again, sort of brings it together in my concern over second guessing. Section 18 says, after the building has been constructed, under plans reviewed and inspections made by the PPP. So in other words, we've had the plans done, inspections are done, everything's cool, the building's now being constructed. Then if the local authority comes in, and of course I told you that you couldn't issue a certificate of occupancy, they've got to do that. So basically they get to come in when the smoke is cleared. They get to look at the whole facility that has been going on under your leadership as the private provider. And if they determine that the building or the plans do not comply with the applicable regulatory requirements, the official may deny the permit or request for occupancy or certificate of completion, or may issue a stop work order for the project or any portion thereof. And I will tell you, at that point in life, that is a catastrophic time to have an unanticipated delay in a project that, because of the COVID-19 issues, are going to create on design and construction anyway. Projects that are going to go forward now just aren't going to have the luxury of a lot of extra time at the end to have a code official come in and say, well, now that I've decided to get involved and look at it, I got to tell you, I just don't like what I see. And then, of course, what then happens is the section down below says, here are going to be the remedies for that situation if it arises. And it's got a variety of administrative appellate process reviews that can take place to see what it is. My experience in having done this with you folks for a long time is that when a code official says this doesn't meet the law, that official may be right, that official may be wrong, but that official ultimately will control the outcome. When my son started practicing law, I said, Taylor, the judge ain't always right, but the judge is always the judge. Well, the code official in the end is going to be the code official. And for you to prove, quote, end quote, that that person's interpretation is wrong, the cost of doing that is so astronomically disproportionate to the benefit that will ever be gained. Ultimately, people will yield, and almost by default, the code official in that instance, the true code official, wins. And when they win, the design professional who did it loses. And if you're the person who was the reviewing code official with civil liability, and you reviewed something that the real official, code official, comes back and says ain't right, and then because of the need to get the project finished, they, quote, win, end quote, in the interpretation, you might have a deep hole to dig yourself out of when it comes time to show that you were right and they were wrong. So again, it just highlights the concern that I've got. And interestingly, Section 19 rubs in the immunity issue to some degree. It says the local building official shall be immune from liability to anybody for anything that a private professional provider did in the action. So in other words, if they give the reins over to you and you take the horse and run it into the river, they're not going to be responsible for that any more than they would have been had they been riding the horse themselves. And so they maintain their immunity. You won't see anything like that for the private providers. They have no immunity in the beginning, in the end, or at any time in between. And so again, if I sound like someone who's paranoid over civil liability, if I were not that way, I'd have been wasting the last 38 years of my life. This is what I've sort of learned to watch out for. So let's see. And again, I guess, as I say, to rub it in, Section 21 says nothing in this section shall limit the authority of a local code official to issue a stop work order for building project or any portion of the project. Again, at any time, I don't want to say at the whim because they're good people, but they're people who, as you know from having practiced with them, will disagree with you, and not you, but anyone out there doing what you all do, over code interpretations. And so when they finally do come up and say they can issue a stop work order, well, again, in today's life, with the project schedules being such as they're going to be, stop work orders are just really disastrous things, and you cannot have them attributable to your view. All right, Section 22 of the disciplinary guidelines says that you're subject to review by the LLR for what you do, and that is, of course, natural. If you need to mute your phone if you're on. I'm hearing somebody, so if you can mute your phone, that'll be helpful. Of course, that may be more informative than what I'm saying, but it'd be good. Then so in other words, you're going to be responsible to both standard of care, and you're going to be responsible to the licensing reviews. And that, of course, is what you would expect when you undertake professional practice, such as y'all do. And then it says nothing in this act will apply to inspections exempted under Code Section 8226.1. I looked at that code section, and the best I could find is the only two things that are exempted are state or local fire safety and erosion control standards. And so as I look at those two things, everything we've been talking about is not something that I understand to be the responsibility of you all if you undertake the task of the private provider. The state fire marshal will still be the state fire marshal, whoever it is that watches out for erosion control. It's kind of an interesting combination of two things there to a project that they elevate to that level. But I can understand fire safety, and that's good, because the last thing in the world I would want you all to be is the final say on the fire safety. It's good to have somebody else out there doing it, but you're going to have to coordinate with them. So just build into your process the same kind of cooperative activity that the local code official would normally have. You have to build it into your practice too. All right, and then the Governor of Community Affairs has a good publication out there where they discuss a lot of the background and related information, and that's the citation to it. Finally, so you say, well, okay, Stair, you've told us all the bad things in life that are going to happen to us. What do we do to protect ourselves? And I have my partner, Tony Mack, and she's going to take up that issue here at the end. We'll be around to answer any other questions, and she can also then provide such comment as the variety of things I have left off. So, Tony, if you will, take it from here.
Thank you, Kent. That was a very informative and thorough discussion highlighting the potential risks that are associated with providing these services. I'll just start off by saying what we normally tell clients, and that while there are always risks associated with providing professional services, most of those risks can be managed or allocated through a contract, and that principle holds true for private provider services. I do have to give a little bit of a disclaimer just to make sure that everyone who's listening in today knows that it's very important that you consult with your firm's attorney so that you can craft an agreement that fits your project, your scope of services, and your firm. The point of our discussion today is to highlight for you things that really should be included within your contract, and then to bring to your attention certain risk allocation tools that are out there and are potentially available to you to help limit and define your exposure if you run into a scenario where maybe the local authority second guesses your conclusions and a claim eventually comes up or occurs. First and foremost, and this may seem a little bit obvious, but you really should have a written and executed contract in place prior to providing these services. We've worked with a number of clients over the years who almost solely operate on proposals, and that's been okay, and no one's got burned too badly over the years. However, given the heightened risks that are associated with private professional provider services, you really, really, really must have a written contract in place. And that contract must clearly define your scope of services. And this is particularly true when you are working with a team of consultants to perform the various inspections that are called for by the code. And it's very important that the owner and each team member know, understand, and document who is doing what and what is going to be done. And then once you've clearly defined your scope of services, make clear that your scope of services will be performed in accordance with the usual and customary standard of care. What is that? That's just the general level of skill and care that is ordinarily exercised by other professionals who are providing the same or similar services in connection with a similar project. And you may be sitting there thinking, why is she, regurgitating all of this information at me? Why is it important? Well, it is important because the scope of services that are called for when you're performing private professional provider services include determining code compliance issues in issuing certifications that the plans comply with all regulatory requirements. And it's really important to make sure that the owner understands what that means in terms of the standard of care in your professional judgment. As you guys all know, regulatory requirements are subject to differing and sometimes conflicting interpretations. So it is almost virtually impossible to certify that something strictly complies with all requirements. Because of that, you should make clear that you are not warranting or guaranteeing that the plans or the work strictly comply with all requirements. Rather, make clear that you will exercise the standard of care when you're performing your services to identify, interpret, and apply the requirements of all applicable law. And that's really the first and foremost thing that we've identified as something that must absolutely be included in your contracts, just to temper the language of the statute and make clear that by providing these services, you're not warranting strict compliance with all requirements. Other things that you can do and other tools that you should consider with the advice of your counsel that will help define and limit your exposure if there's a problem down the road include consequential damages waivers, which is a tool, if agreed to by the other party, that will allow you to limit the types of damages that an owner or a contractor or whomever you're contracted with will limit the damages that they recover. Consequential damages are certain things like loss of use, lost profits, extended premiums, and things of the like. If you have that waiver in place, that will cut down on the type of damages that the other party will seek to recover from you. Now, with indemnification provisions, we typically talk about those in terms of a design professional agreeing to indemnify or hold harmless an architect or an owner. There are circumstances in which that you yourself can request an indemnity from the other side. Given the exposure and the risk that you're taking on, it is not unreasonable to request that the other side, whether it's the owner or whomever else, indemnify you in the event that there is a claim for something that does not relate to your negligence or your scope of services. And that will help protect you and your firm from exposure to costs and fees that really aren't your fault. And last would be damages caps and limitations of liability. A bit more of a disclaimer is that the law regarding these provisions is very, very, very finicky. They have to be carefully crafted, but if they are carefully crafted and they're worded properly, then they can be used to limit the ultimate amount that you would be required to pay in the event that you have a claim. So again, that's just another tool that we think that you guys should consider. And as you're getting your written contract into place prior to providing these services, talk about these things with your counsel and consider including them in an effort to limit your exposure and temper your risk. That's it. Jeff?
All right. Thank you, Tawny. I guess I need to click screen share here. You cannot start screen share while others participate. Let's see. I think Chandler, you gotta approve me for screen share.
Yes, you should be good to go now.
Okay, so can you see my screen now?
Give me 2 seconds.
Chandler, this is Ken, I turned my share off, so I should not be hogging the screen.
Okay, let's see. I think I can do it now. All right, can you see that? Good to go?
I see you, Jeff.
All right.
I see you, yeah.
All right, so let me get, I'm gonna go ahead and, we have the experts here with getting into the depths of the law and how it pertains to you guys. And they're really the experts on the interpretation of what's going on with that statute and the executive order. But I just kind of wanted to talk about, let's see, it's showing, are you guys seeing all my slides or they're just the main slide?
We're seeing all, I think, put it on slideshow from the beginning.
I did, and it moved it to my other screen. So let me do this. Let me move this over here.
When you're taking technological advice from me, Jeff, you are in deep trouble.
Let's see. Let me share a different screen. Let me share this screen. There we go. Is that better?
Yep, you got it.
Yeah, that does it. Yeah.
So, so here's the what's actually written in the statute as it pertains to the insurance. I just want to review this with everybody. So it says all private professional providers should providing plan review or inspection services pursuant to this subsection shall secure and maintain insurance coverage for professional liability, errors and omissions insurance. Limits of insurance should not be less than $1 million per claim, $1 million in aggregate for projects under $5 million in construction value, and $2 million per claim, $2 million in the aggregate for projects over $5 million in construction value. This is actually paraphrase, this is actually part of the statute as well. It can either be a practice policy, which I'm sure all of you that work for engineering firms have a practice professional liability policy in place, or it could be a project specific. I don't see in really any scenario where you would have a project specific policy purely for third-party review services, but that is in the statute. If some crazy reason that did come up, it must have a 2-year extended reporting period from final completion. Interesting, the statute did not require that on the practice policies, but in the real world scenario, your practice policies are going to renew every year, so you're going to have coverage past the substantial completion on the practice policies as well. So as far as your insurance language goes, how is it going to respond to inspection and third-party review services? You need to speak to your individual agent or broker, whoever provides that professional liability insurance. Every insurance policy is different, but I wanted to give some sample language of a very common professional liability insurer here in the United States. And in most quality, what I would call tier 1 professional liability carriers are already contemplating this type of services that may be performed in just everyday type of services, whether that be peer review services, inspection services, permitting services. The way the coverage is kind of given is you have your insuring agreement that the insurance company is going to pay all amounts that they become obligated to pay as a result from a wrongful act. Policy goes to define wrongful act as an error or omission or other act of liability caused in the performance of professional services. And then professional services goes on to be defined as those services right there. These are very common definitions and languages that are used in professional policies. And when you go to look at exclusions in the policies, you'll find that there's usually, with carriers I've placed clients with, no set exclusion for any inspection type or review type services, code services. But the key is, like Kent and Tawny mentioned, is you can't ever guarantee or that a plan or project is 100% to code. So that's where if you raise your standard of care and guarantee that something is exactly to code, you could come into some issues with your professional policy responding, as they could look to the exclusion of warranties and guarantees as a way to preclude coverage, as they're only covering your professional services as it contends to negligence in your standard of care. So that's very key to make sure you're not guaranteeing any of those review services. I've already seen a couple applications. I've seen City of Atlanta's, I've seen for side counties. I think I've seen another one, I can't remember it off the top of my head. I had clients saying that they want to start performing these services. And then here's the application, Jeff, where you review it. There's insurance requirements in here. So you want to make sure when you're submitting those applications to do those services for different municipalities, you're reviewing that with your insurance agent or broker. This is some example wording that I've seen on these applications. So this is one of the key ones I've been pointing out to my clients. So it's saying, XYZ County of Georgia, its officers, officials, etc., need to be named as an additional insured on the required insurance policies. On this specific one, they wanted on all insurance policies, including professional. Whether you're aware, I don't know how involved everyone on this call is with dealing with insurance on a daily basis, but that can be done on professional liability. You cannot provide additional insured status. So key reason right there to have your agent or broker reviewing those applications. I'd also seen the City of Atlanta requires additional insured status on the general liability policy. Well, most general liability policies include that coverage if you have a written contract. Well, now we're in a catch-22 maybe of, is the application submission to perform those services considered a written contract or not in the eyes of the GL liability carrier to provide that status to the City of Atlanta? I would argue probably not, that you actually need to have a separate contract, or you need to specifically add the City of Atlanta to your general liability policy in order to provide the coverages that they're requesting on the application. So once again, every municipality is going to be different. You need to review those specifically with your insurance broker. And then this is just another thing on the City of Atlanta's application. They only require 1 million limits to submit an application. So you just need to make sure that even if you're approved for the City of Atlanta, you start doing work, if one of those projects you're reviewing for them is over 5 million in construction value, even though the City of Atlanta didn't require that, you may be required by the statute to be carried in those limits. That's it from my slides. I did want to mention too, how do carriers look at these services? So, in most applications, there's actually a box there that's asked what kind of inspection services are you performing, and they want to know a percentage. So as I said before, most all carriers are contemplating that this could be part of the design firm's professional services in general. But over the next, say, 6 months, if your gross revenue swings to 20% of inspection services, each carrier is going to be different, but that could impact your premium in a certain way. And you need to have those conversations with your individual agent or broker about how that could affect that. That's all I have. If we wanted to maybe open it up for any questions, or Chandler, I didn't know if you wanted to field questions and read them off to us, or how you wanted to do that.
Absolutely. So I see there's a couple of questions in the chat. Let me see. Let me go up to the top. So we have a question from Brandy. When waiting for the local authority to review your inspection reports for the 2 days, does the project stop to wait for the audit?
I would say no, because that would assume that there's going to be a problem and the project is not going to have enough time to every inspection, wait 2 days to see if it happened or not. So no, I mean, I would say the project should continue on, would be my thought on it. And having said that somewhat boldly, I realized it's really never been this act involved in an appellate decision. So who really knows? Tony, Tawny, you usually have better thoughts than me. What are yours on that?
I will note, again, there are no decisions on this, so we're just going off of the text of the order, but the text of Governor Kemp's order specifically states that all time requirements within the private professional provider statute are waived. So if that 2-day time requirement is coming from the statute, then it has been waived by Governor Kemp's order, and the project should go forward without waiting for the city to comment.
I think it would just be practically impossible to wait 2 days to see if someone is awake and wants to have something negative to say at the inspector's office. So I would continue on. Good question, a really good question.
Awesome. Okay, so next question I have. As most airports and other facilities have federal funds, would these state ordinances supersede all public projects? I'm sorry,
Well, I'll go on.
I'm reading 2 questions at once. So as most airports and other facilities have federal funds, would these state ordinances supersede any public projects? That's the question.
Well, again, I've spent a lot of time talking about things I don't know anything about, so why should I stop now? I mean, it seems to me as though it's a building code issue. And so if it's a federally funded project that still has to go through the Georgia local building code, essentially you're providing whatever service that code official would be providing, and however they interrelate with whatever the federal funds or the federal authorities may be, I guess is something that you'll have to figure out. But you really do no more or no less than what the local authority would have done had they been in place. But I don't think that the fact of federal funds changes the building codes as they relate to state minimum requirements from Georgia state and so forth. And again, I'll turn it over to Tawny because she always exceeds my thoughts wonderfully, and I guess somewhat understandably. And then Sully or Jeff, anybody else wants to comment on, by all means, jump in. So Tawny, you want to take a shot at it?
Sure, and I think I'm just going to state what you said, but a little bit differently. So without knowing the project and knowing too many of the specifics, the private professional provider is stepping into the shoes of the local authority having jurisdiction. If there are federal requirements on the project, Governor Kemp's order does not impact those requirements. It relates only to the requirements under Georgia law that relate to enforcement of the building code. So if there's a federal review that's required in connection with the project, then the order would not impact that review.
And you're not doing the federal review. I mean, you're not the federal authority, you're the state and local authority. Next question, Chandler.
Yes, sir. All right. I have, is there a commercially available standard form of agreement that you can recommend?
That was simple, no. Tawny, is there any variation to that answer?
There is not a commercially available agreement that's specific to these types of services, but I think that the AIA and the EJCDC agreements, I probably got the acronym wrong, I apologize. They can be easily adapted to fit these types of services.
The point would be that neither of those bodies anticipated a situation where private people would become the public entity, I suppose. And this obviously is the result of an emergency. And so they would not have those kinds of agreements. And what Tony says is, so basically you're going to have to get the ones that did anticipate a somewhat normal review inspection kind of thing and then modify them. But no, there are no standard documents, because this is a very non-standard situation we find ourselves in.
Alrighty, and the last question I have is, does the state law create a price bidding war among all entities and lower the final product quality delivery standards?
Okay. Price bidding among who? I guess I'm not sure I understand the question. The tempting answer would be, will people start bidding as the low bidder to become the plan reviewer? I can get it done by this one for X. Will you go X minus Y? Sure, I'll do that. I don't know if that's the question, but it's like everything else in practice. There'll always be people who are willing to undercut you on your price and most likely underperform you in your service. And at some point, well above a good standard of care, you need to let economics and professionalism stand in your way of getting into a bidding war. But that probably wasn't the question, but the commentary is probably worthwhile. But Tony, did you understand the question? In another way, whoever asked it, please, clarification. I don't want to dodge the question. Tony?
I did get some clarification here. As
Okay.
a follow-up, as these are professional services, would there be a separate pre-qualification list for all PPPs?
Okay. Tony, I babbled enough on that. You want to give it a shot?
Sure. So with respect to the list, I mean, you have to apply with each local authority, and I believe some authorities are publishing the list of qualified private professional providers. I know that some industry organizations are also maintaining lists, but the list would not include, without getting too deep into antitrust concerns, but the list would not include like a standard price for the cost of those services.
Nor could they, because there is no
Right.
standard service in this. I mean, you've got a project of different complexities. You've got a project under different time requirements, under different budgets of reality. I mean, there's just so many things. And what I really do urge you to do is, when you set your price, if you will, whether it be by the hour or lump sum or whatever you think it might be, I urge you to build into your reward enough additional compensation to take care of what I consider there to be some additional risk to what you normally do. And so, you know, don't underprice yourself on this, because it's something to keep you occupied. If you're going to get in a lot of trouble with a price you can't do it for, and then have risks that you just simply didn't take into a proper account. So have what it takes and make sure you get paid for it.
And Chandler, ACEC is putting together a list, aren't you guys, of competent providers?
I believe so.
Yeah.
Yes. That would.
We have. I'm sorry. Go ahead.
I was just going to say an additional point of clarification that may help clean up the question is, so it's not the municipality or the local authority having jurisdiction that hires the private professional provider. It's the project owner who will hire the private professional provider, but that private professional provider has to be qualified to perform those services, and you become qualified by submitting an application to the local authority.
Right.
So someone's going to come to you and say, will you be that person? First of all, you got to be qualified, pre-qualified, whatever it is, to be that person. And so the answer becomes hopefully yes. And then the question is, well, what will the fee be? And so you then negotiate the fee with whoever it is, the same way you'd negotiate your professional fees. And it has to take into consideration all the factors that you're about to embark upon. And, you know, if you do have to account for a team of people that's bigger than, you know, your own internal shop, all of that has to be factored in as it would be in any kind of professional engagement.
The list is actually on our website. And if you have any questions or anything, you can email Ashley Jenkins, who is our Director of Political Advocacy. And she can answer any questions anybody has about it. All right, so well, I do not see any other questions in the chat. So thank you guys so much. We really appreciate the insight, and I'm sure all of our participants got some good takeaways from it. So if anybody doesn't have anything else, thank you so much. We really appreciate it.
Thank you all. I enjoyed it. Stay safe out there. Bye-bye.
All right.